Abusuafoɔ ne atiifoɔ yɛ ma obi a kwabado by Alpha OneTV. Sɛ wɔtahwɛ anaasɛ no na first time aba nso a ɛne de no bu kwan so na subscribe ama sɛ bi news bi a na ɔhyɛ bi a wobɛnya notification of phone so abɛhwɛ afei nso ma memfi so bɛhyɛ ama wadamfo so ɛnyɛ bɛtifoɔ meyɛnka nsɛm so ten. Yɛnim sɛ CJ Torkonoo yɛnim sɛ ɛnora ne bɛtɔ dwa me hu sɛ wanominate ɛgɔfrɛ dame sɛ ɔno ɔnyɛ ne lawyer. Na CJ ɛde nsɛm bi kɔto Supreme Court for anim. Aka sɛ nkebe a committee na NDC for artists or mohwehwɛ na ɛyɛ ne nsɛm no about the petition for the hair removal from the office no. Kebe a ɔmo in camera. Na no ɛna NDC lawyer a jeton so aba abɔnten ɛka sɛ nneɛma na Chief Justice ɛyɛ no ɛni mmerɛm na yɛabɔ ato agu ɛni like so far as on ankasa the law is the law in the bibia ɛwɔ Supreme Court bibia ɛwɔ any court bia na bibia ɛwɔ Ghana bia no nobody is above the law. Even the court na ankasa is not above the law. He's not above the constitution and the adwuma. So yɛma media for kwan ɛma mo Supreme Court bi twa no ɛnkyɛ sɛ ɔmo yɛ de ɔmo bu mmara wei so no ɔmo media for kwan ɛma mo twa nneɛma mbɛn in camera. So nneɛma a ɔmo ɔkɔ no like secretly na back camera mu no Supreme Chief Justice suspended Chief Justice ne ka sɛ nkebe ya nkoma ne mbra camera no obi ehu sɛ attention ne ɛkɔ no ɛno na NDC lawyer na yɛ abo to agu ama sɛ no anim gwa sɛ Kesi pan ne ato ɔmo agye sɛ nya asɛm because we den according to nneɛma NDC for manyoko ne ka we den abɛkɔ ko petition ne de aba no ano ɔhye pa na nipa ko asa afa na sɛ ɔno mo zangosi wa na campus ayi nim gwa sɛ because yɛ de ɔno be lucy ko NDC for kuku damfo ne ho kuku damfo ne ho ɔre kam ne nkuti lawyer ene nneɛma yɛ ansansa so de to ase ba ne de nkomo twa de ato aso
hearing the Senate hearings were always in camera. And so it is not too difficult. And if you look at 1468A, again, my position on the law is that the fact that the provision says it shall be in camera doesn't mean that we cannot interpret that to mean that we can have it in public.
Abraham Alaba, John Darko has a point, as you know, that even if you just go beyond the constitutional provision itself, what do you lose if you open up this committee hearing to the cameras? In fact, don't you rather gain transparency? You actually gain a bit more openness to the process, and that citizens can then follow, and you'd then rule out the possibility that this may be misconstrued in the eyes of the public. This is good for democracy, as you know.
Democracy is different from what the law is. The law is not democracy. Democracy is not the law. These are two different things. Good governance is what you are talking about, but the law is the law, as its embattled Chief Justice said. Clearly, the Supreme Court is under the Constitution. The Supreme Court is not above the Constitution. The Supreme Court can only do what the Constitution says it can do. The Supreme Court cannot do what the Constitution doesn't say it can do. And so, if we are advancing the argument that even though the Constitution stipulates how these matters are to be dealt with and says that the hearing must be in camera, but the Supreme Court should go beyond the Constitution, then we end up not having a Constitution at all. And we can't just say that we should allow the Supreme Court to do what it likes.
But what real purpose does it serve to have this in camera when the person who is accused says, I'm ready to waive that?
I want to believe that the framers of the Constitution were of the view that such matters, because of the position of the Supreme Court, there are some information when it is leaked may have some negative impact on the country, probably matters of national security, the same things that she's talking here, my colleague is talking about public health matters. We don't know where it will touch. We don't know which of our life as a country that this may negatively impact. And so the framers of the Constitution, I'm just thinking for them, may be thinking that because you don't want to spill those things in the public domain, it should be held in camera. The issue that in the past, the Supreme Court, or is it the courts, did not allow cameras into the courtrooms, but now we have it, is different from this. In that situation, we didn't have provisions proscribing the use of cameras in our courts. It was just a practice, and so you could easily do away with the practice. But in this one, it is clearly stated, and you cannot. You could have as well said, okay, the two justices should also sit. We should go and bring justices from other countries. Or we could say, but the Constitution has stipulated how, the way and manner in which this must be done, and you have to respect it.
But Council, if I may just chime in,
please.
See, what is happening here is not going beyond and above the Constitution. I think that what is happening here is just interpretation of Article 146A, which says that the committee shall sit in camera. Okay, so just interpreting that provision, and we know, like I said in the Akufo-Addo and Mohammed's case, the 2013 case, the Supreme Court interpreted SHA to be permissive. More or less, SHA is not mandatory and that it could be permissive. So we can say that the fact that SHA is there, the fact that 146 says SHA mean may. And so it is not necessarily binding and that they can waive it. Our Supreme Court interpreted SHA in 2013. They said that it doesn't necessarily mean that SHA is compulsory and that we may interpret that to mean may. And so let's instead of SHA, let's put may there, and you see that it will read nicely, and the Supreme Court can easily say that, okay, we will give you the right to be heard in public. And so there's an option. We cannot say that there's no option because of the way 146A is, crafted.
No, that type of interpretation is not done in just, where may is interpreted to mean shall and shall may. No. In situations where a person's rights would be affected, that is when you would interpret may to mean shall. So, for instance, if you say you may, after a committee hearing,
somebody's right to be affected?
After a committee's hearing, you may give Evans Mensah the proceedings of the hearing. Then you say, oh, it says may. But you know that Evans Mensah needs that report to mount a case in court. At that point, the court will say it's a shall. This one, how would the hearing in camera affect her rights? How would that affect her rights?
Of course. I mean, the people of Ghana need to know.
It's not about
wait, my brother. She's been accused of so many things, okay? And already we all know, you and I know, that the petitions are in the public domain. And so people want to see how this will be proven before the committee. People of Ghana, for whose, interest and this justice, is done, need to know, because this is, and let's be careful. This is the first time one head of the arm of government is being removed. The people of Ghana deserve to know. They want to follow what is happening. And she herself will want the people of Ghana to know her position, because she's been disgraced with all these petitions. She wants to prove her case in court. I don't think that.
John Darko, stay with me. Stay with me. Let me bring in Asasari. Mr. Asasari, is it her right to waive?
Hello?
Yes. Is it her right to waive?
You mean the lady Chief Justice?
Chief Justice, yes.
No, the Constitution doesn't put, the applicant, to an election to elect whether to waive or not to waive.
She's the accused in this case, and she has everything to lose, right? So you think that this clause was put there in the interest of natural justice and also in protecting the rights of the Chief Justice in case anybody triggers it. Isn't that her right to then waive if she doesn't want to?
No, the answer can be found in Article 125. It says that even though citizens' participation in the administration of justice must be encouraged, it is subject to the Constitution, and therefore the independence of the judiciary is itself subject to the Constitution. As a clear language of Article 125 of the 1992 Constitution. Now, remember, Kofi Kumado once said that democracy is not synonymous with constitutionalism. So the two are different. Yes, democracy, but the Constitution, speaks in peremptory language sometimes when it starts. Then thirdly, I think this is one of the instances where Atta will describe, the operators of the Constitution, as not only subject to the Constitution, but also to be, constantly reminding themselves that the governance institutions that are being created by the Constitution are to aid them to behave themselves, right from the presidency to the media practitioner. So the Council of State is there, it has been designed to aid the president, to behave himself. In like manner, the Judicial Council has been established to aid the Chief Justice, successive Chief Justices to behave themselves. So if the incumbent Chief Justice has a problem, her first port of call will be to seek counsel, wise counsel from the Judicial Council. I don't think that has been done. And therefore, all these things that the Chief Justice and the lawyers are simply amount to a provocation of the committee. Provocation of the committee. Their acts are designed and have been skewed to provoke the members of the committee into doing things that will turn out to be unorthodox, unconstitutional. So I would deem the whole thing to be a provocation of the committee. The CJ removal process now has been so engrossed in politics that the whole thing is political. So issues of transparency, legality, and all that.
I may have lost him there, but he just touched.
Have to uphold the Constitution, please.
Yeah, I mean, and you touched on the politicization of the process, and I want to bring in John Darko. John Darko, today we learned that in this process that the Chief Justice has commenced at the Supreme Court, her lawyer is going to be the former Attorney General. Was that a prudent move, considering how politically exposed, and putting it mildly, the former Attorney General is, and the former Attorney General who was instrumental in the process of nominating her to the bench, to the Supreme Court as a Chief Justice, not to the Supreme Court, but as a Chief Justice? Was that a prudent thing, considering how politically charged this whole process is?
Well, I mean, so this whole thing has indeed been political. And from day one, it has been political. The president of the Republic, before he became president, had promised his NDC base. He had promised the NDC lawyers at a meeting that when it comes to power, he will make sure that he will reset the judiciary. And we have noticed that the first set of resetting the judiciary is to remove the Chief Justice. This is the first time, I believe, in the history of this country where within the first 4 months of an administration, seven Supreme Court justices have been nominated. President Kufuor nominated his first Supreme Court judge 2 years after he came into power. Nana Akufo-Addo nominated the first 2 years after he came into power. President Mills nominated the first one. He did that one also early, but it was just one person, I think, within the first 5 months. This is the first time we've seen 7 Supreme Court justices nominated. okay, or nomination to the Supreme Court Justice within the first 4 months of the administration. This is politics at play. And I think I've made that point clearly, that what is happening here, we can always look at the Constitution to, as it were, cover the politics that is happening.
Are you suggesting that in the decision to select or choose the services of Godfrey Dame, the Chief Justice is aware of that, and so she's aligning with the NPP side in Godfrey Dame representing her?
Well, those are your words. You know, I've never said that.
No, I'm clarifying. Only because when I asked the question, you went to make the point about politics.
Yes, because this is politics the president has engaged in. He's political. In fact, the last time I met one NDC panelist on CTFM, he said that what the president is doing is to balance the judiciary by appointing 7 nominees to the Supreme Court. He was balancing the court. That is an advisor to the vice president. He said that.
I guess my question
to you. So I'm saying that.
What does that got to do with Godfrey Dame?
Treats the Constitution, as if it's a convenient document.
Is there a constitutional basis to waive that clause that says this process must be held in camera?
So look, if you look at Article 146A8, which talks about the fact that the committee shall sit in camera, I think it is a basis for which my co-panelists are saying that the provision is so clear and that you cannot do anything about it. But we know that this same Supreme Court, our Supreme Court, has interpreted shall, okay, because we are talking about the fact that the Constitution says it shall be in camera. The Supreme Court has interpreted shall to mean not that provision may not necessarily be binding. I mean, in the Akufo-Addo and Mohammed's case, we know how the Supreme Court interpreted shall.
At first, na ye makwankwa media for embunra court some kwakucha near me cause ruling ekoso. Na ye makwankwa mungu cha. Although be on the right, so ye then or chena way, But according to the Constitution, or say, and ye be beyond bit me a shall replacing me. The moment it be replaced that was nepet, that means that a year article no be affecting the back on the right. But we know I affect she, then affect it. Ye come remove, affect or she. NPP Nina on the legal a councillor at the minority in parliament no. Fenema or Kaka, Fenim Guansia or Jivo. I was in come because they bear fit on the right be. Right be affeton. Right be. Count minka now Rosso. Council minka and this line I a discipline patch say na enya some kutwa. Na Ovino and I say that request no dear bano. Or do be a bit much an because ye pesi in feel. Or no one was a pay no some penny in feel. NPP for someone pay money in feel. After your markets in democracy. Because kids be your parliament or benyo be and now the Saki now Cordano. Within 48 hours on Bebusa a case no matter say dear my for your markets. Ain't for your markets any bring in a chesem pese mammy the exact now. As a dear man's or so mammy. Because a partisan politics or a Supreme Court. Mammy can't say a year or more or Supreme Court and give a committee no. Or can be in Chrom or Moncase. Near Mokwakwe and say examination Mokwakwe about the petition or Monina a Gana for Yine. No more on a Chief Justice Torkonoo the suspended and outgoing a Chief Justice no. No more something upon no near she numbers on me and there some toneso. Until no ain't no some yen or monye our Camry. But Constitution in the age, Juana because the law is a law, no matter the noise that you make. Na no kwampa was nka umumu ya pie our court no. Usuma okunu mum ne mane court. Wankasa mum de wanyede. When has a opportunity na anko. So want to fee and I munye mami. Tia yet kwampo chese. Ehem confedami ne besa yo lawyer. Confedami cases are all saying away dear we wini. Our coffin as a lawyer. Can't for someone taja kwampo. One vote me as a confedami. The former AG. And committed this AG. Dominicaini. And fa. As I committee NDC lawyers or moon nimde. Kushes and go for him. And yadia will be wini. Yadia be Lucy. And fa. The very young step back. He be more resign prakope. Nako. Because never be about any and enguzi she. Petition of the hour prakofi. No, we know, and I'll say. Years back, no, some more be become poor Supreme Court, and also maybe be a court. Dang. 7 better so. The paper wants to say, ye call court, no, see, ye, but it ain't some percent a year, will be like near my a coso a year court near the day for a year. Bit me soon name be free because of here you school near the amount for bomb here down to Ghana no. Or me who send ya ye near my court inti. Or more the cameras abem say be ya come here the more record it or more say be Ghana for ya be who near my course or a court. Na ya this one there am obiano. And you not just say or more breach the constitution of Debbie. I no compono or more and share masses in the same ma obiama ni be try. But we know a constitution him. Say BB says no mum kwa showing some new one. Ye ma obie hu. Mommy we are not the outcome na about one say. Ye quite no silly see. But mammy is one penny. A legal counselor any minority for. Also, if I dark on so bad one thing, I can say be in some any quansoka. Say, I may shall meet my place no ha. And I need to learn I can say, I need to meet my place because I have fets in the right to be a right to be now fets. A while now, Rosso, dear onka. It is that a request now a chief to corner, and this lawyer for company guy about to get a dada. I just any day, and yes, and go to. So after your markings, no, and it does one some say near my pastor court in the anti found could be only part of our down ye baby in a few. Because where aunt gone chief justice, because where I'm gonna be no macaca, and just will be gonna for so be a babble thing. I just say almost 50 plus, almost a chief justice and uncle. If it's my chair, I will comment such a bit to a share more down for saying a biash. I have 4 Judicial coming now.